Hey guys, we're going to be doing a deep dive into the Anthony Sims case. Now, we already know the outcome for this one. His conviction was overturned on the 10th, so a few days, or is it yesterday? Don't quote me, I think it was actually yesterday. But we're going to go through this journey from his initial post-conviction relief and some of the issues that took place while he was fighting to maintain his innocence, and all the way through how he got here today. The reason I'm excited to do that is sometimes we'll watch oral arguments right when they're happening, and everyone's like, well, we want to know the outcome, and you don't always get to see the outcome right away. So we're going to get everything. We're going to do like a case deep dive sandwich here. Now, the case of Anthony Sims, when it was happening, it was largely referred to as the raw chicken or the undercooked chicken shooting. And we're going to go through a background on the case. We're going to go through a bunch of different articles. And as a precursor, if you're someone that likes to read, if you look in the description of this video, there should be a link to a Gamma document. And in that Gamma document, you'll have all the resources that we looked at here. So nice and easy. And I'll show you what that looks like. And the reason I've been trying to do these is it gives you a quick way to jump back and forth. If you just want to read the opinion, you don't really care about the case background, I try to provide that document. If you want to know all the context, and we're going to read this for the stream, this is how this case went. So all the way back in 1998. 1998. 27-year-old Li Run Chen. He was shot and killed with a single shotgun blast at Mr. Hing's kitchen. This was a Bushwick restaurant, takeout spot. The shooting reportedly grew because of an earlier argument involving undercooked chicken, where Chen pulled a gun on a complaining customer. Anthony Sims was 22 at the time. This has been a real long saga for him. So, like, more than half of his life has been spent dealing with this. We're going to hear that he got out on parole in December of 2022, but still was incarcerated for over 2 decades, and still after he got his parole, he was fighting to overturn his conviction. He'd just gotten married. Keisha Sims has been by his side. We're going to hear a bit about her, so shout out to her. He was working for a phone company. He had kids. He was accused of driving Julius Graves, that's going to be an important name, and others to the restaurant for revenge. So this altercation, somebody gets upset that this chicken was raw, they're fighting, and then they get upset that the owner pulled a gun at them and told them to leave. And later on in the night, they purportedly all go back together in this car, seeking revenge. So there's no actual physical evidence that tied Sims to the gun or the scene. There's no fingerprints, there's no DNA. The gun was kept in Julius Graves' apartment, and Graves says, yeah, I wiped the gun down, I wiped the fingerprints off the gun, but I didn't actually shoot anybody, according to Graves. Graves was never charged. Instead, the case leans heavily on witness testimony, Graves being a key witness, and Graves will end up saying he saw Sims do the shooting, and 2 other teenagers in the car who were connected to Graves' family. So those are the eyewitnesses that were being relied on. We're going to hear that there was a recantation from a witness, and then a witness that came forward that wasn't available at trial, who was like, no, actually, I identify Graves. It was Graves. So here we go. Initially, the jury deadlocked. The jury was deadlocked initially. And I feel like we're hearing that time and time again. They ultimately convict. So he's convicted of depraved indifference murder and weapon possession, but not intentional murder. He's sentenced to 25 years to life. Sims, again, as we know, he maintains his innocence, and that Graves was the actual shooter. He was saying at the time that Graves was the actual shooter. We have hidden witness evidence we're going to talk about. We've got undisclosed background on Graves. So Graves had a criminal history. He had probation issues. He was also given certain benefits in exchange for his cooperation, but that stuff wasn't disclosed to the defense team prior to the 1999 trial. He was also given money for witness protection. So there was like a financial component, a financial benefit to his cooperation. And we know there's conflicting stories. We're going to hear more about that. I don't want to get too deep into that with a quick summary. Now the timeline. Why did this take so long? So again, he ends up spending more than 2 decades in prison, about 24 years and change. He's incarcerated wrongfully. In 2016, he asked Brooklyn's Conviction Review Unit, and this is why this case was ever on my radar. So it's really called I refer to them all as Conviction Integrity Units, CIUs. Several states have them. Some of them are like jurisdiction-based and not necessarily statewide. But there's some interesting research we'll touch on a little bit about how productive, how efficient is this really working? Are these conviction integrity units really doing what they're supposed to be doing within the state of New York? And again, this is a New York case. So he asks this review unit to review the case. First, they deny that effort. It's going to get good. This is going to get good. His lawyers and supporters keep pushing. They keep saying, like, look, you have a witness that recanted. You've got all this evidence you didn't disclose. There's all these other issues with the original case. Like, this is just an injustice. So everybody was still advocating for somebody to at least take another look at this case. We've got, again, December 2022, he's released on parole. We're going to read some statements from that release. And then there's a post-conviction hearing. Judge Danny Chun is going to deny relief here, finding that the new evidence didn't establish the innocence standard. And then we're going to watch the oral arguments and read the ultimate opinion. So let's get into the actual nitty-gritty, the details. That's the top level, you guys. This is from New York Focus. New York Focus is the publication that I think like last year sometime I'd started to see their research and their reporting on, hey, is New York's conviction integrity units, like, are they really accomplishing all that much? And the numbers were crazy. It was like they reviewed, let's just say ballpark, they reviewed like 800 cases. Their intake was 8. They actually find problems with 3. And then the problems they want to say were identified problems. They never wanted to attribute one of the flaws, why there was a problem with the conviction, back to the prosecution team. It seems like just by the numbers, they really didn't want to say, hey, there was a wrongful conviction and something could be attributed to prosecutorial misconduct or other shortcomings. So really interesting data. I'll try to share that with you guys. I got to go find that. And maybe we could just do a whole stream on it. It was great research. But they had done, one of the cases that they looked at as part of this review was Anthony Sims' case. And there's some tea here. So here they've got, and again, this is all the way back September 23rd, 2021. It's Ethan Corey and Elizabeth Weil Greenberg. He says he was wrongfully convicted. His trial prosecutor led the conviction integrity unit that rejected his wrongful conviction petition. So his trial prosecutor is the one who said, nope, I'm not going to look at your case to determine if maybe there was a wrongful conviction here. Isn't that something? Isn't that something? So Anthony Sims' case shows the conflict of interest inherent in conviction review units led by former prosecutors. Yeah. We've got a similar like conviction integrity unit over in Georgia. If Bama Rose is in the chat, and I think Hal has talked about it a little bit too. They've sent over some information about that where we have some questions. It's like reviewing hundreds of cases, and the total intake that they even want to review is like 3 of the cases. So on the right here, I think it's important to shout out, we've got Keisha and Anthony. So again, you know, they were newly married right before this all happened. That sucks. That sucks balls. Like, that sucks. That's crazy. It sucks to be wrongfully incarcerated, but dang, like everything's going good and then just life hits you fast. So love to see that picture. They're going to do some background on the case here. A little bit more here inside the restaurant. Sims says he saw Graves take out a small shotgun, point it at the cashier, Mr. Chen, and shoot it. He and Graves then ran out of the restaurant. Less than 24 hours after Chen's murder, Sims was the primary suspect. At trial, the state's star witness was Graves, who testified that Sims had shot the victim. In a trial that Sims and his attorneys say was marred by false testimony and improperly withheld evidence, Sims was convicted and sentenced to 25 years to life. For more than 2 decades, he's tried to overturn his conviction in the appellate courts without success. Research shows challenges to wrongful convictions have extremely low success rates. Even defendants who were later exonerated by DNA evidence had their appeals rejected in more than 90% of cases, one study found. And maybe this is the link. Oh, no, this is a different one. This is from Vanderbilt, and it unfortunately says page not found. So that kind of sucks. But interesting little marker, like ballpark there. In 2016, Sims wrote a letter to the Brooklyn DA's Conviction Review Unit, or CRU, asking them to investigate this case. They rejected him. But the CRU's preliminary review may have been undermined by a fundamental conflict of interest. Do you think there's an odor of mendacity? Mark Hale, who led the unit from its creation in January 2014 until July of this year, was the lead prosecutor in Sims' murder trial. In court filings and statements to the media, the Brooklyn DA's office has said Hale recused himself from reviewing Sims' case. Public defenders and advocates for criminal justice reform say Sims' case highlights an inherent problem with the Brooklyn CRU and similar conviction review units in DA's office across the country, in which prosecutors serve as the gatekeepers for potentially innocent people seeking to overturn convictions that resulted from their own misconduct. And not even their own misconduct, but their own genuine mistakes or oversight. You know, people don't want to admit when they did something intentionally bad. They don't want to get caught, but I think people are reluctant to admit when they realize they're wrong. And when someone might be wrong, I think they're reluctant to even have some self-awareness to consider if it's truly a possibility they may have been wrong. So, seems like a fundamental conflict there to me. Brooklyn DA Eric Gonzalez is searching for a replacement for Hale, and defenders are urging, this again back in 2021 when they're writing this, and are urging him to hire someone from outside the DA's office to lead the unit. So stop reviewing yourself. A new head of the unit, Sims and his attorneys hope, will give his case a fair review. So we have a quote here. It says the bottom line is that the DA's office is fighting to uphold Anthony's conviction despite overwhelming evidence that Anthony's innocent and never received a fair trial, said his attorney, Jonathan Hiles. Anthony should not have to suffer further years in prison while a hearing and likely appeal wend their way through the legal system, even as prosecutors possess evidence showing that Anthony belongs home today with his wife and kids. So then we've got a little more context. No physical evidence links Sims to the crime. The gun used in the murder was kept in the apartment where Julius Graves lived. After the shooting, Graves told police that he took the gun home with him and wiped it down to remove the fingerprints. Sims and his attorneys allege that police and prosecutors, including Hale, illegally suppressed evidence of Sims' innocence and pressured witnesses, including Graves, into making false statements. One eyewitness who knew both Sims and Graves called police and told them that she saw Graves, not Sims, running out of the restaurant with a gun in his hand. That's according to a report by Graves' fiancé. That's come from Graves' fiancé. According to Sims' attorney, Hale never disclosed this information to the defense. So they have an eyewitness who called the police. She didn't call somebody and we're taking their word. You know, she didn't call the fiancé and say it. She called the police and said it. And it's not disclosed to the defense. So there's Mark Hale here on the right. Graves' testimony was essential for the prosecution's case, because of course it was. However, 3 days into the trial, Hale told the judge that Graves was nowhere to be found and asked for a material witness order. So they need to make him show up, which allows law enforcement to take a witness into custody to ensure they appear in court. And then we have Hale, this is the prosecutor, telling the court, "It is my belief Mr. Graves will indicate he in fact saw the defendant shoot and kill the deceased in this case. As the court has obviously seen, I have nobody else that has said that, so we can't just use another witness. We need him. Any of the other testimony wouldn't really matter unless I can get Graves." Now that right there is pretty telling, right? If you don't have Graves, do you have a case against Sims? How strong is your case against Sims? Hale then obtained a material witness order for Graves' fiancée as well, even though she was never called to testify at trial. So to make sure he can get the witness he needs to win his case, he's going to drag somebody else into it. There's a civil lawsuit happening, I think down here in Florida. I'll pull the case. I forget her first name, but her last name's Jeter, like Geter. And she filed a lawsuit because she was subjected to something similar like this. And the prosecutor, she has like a recorded call. The prosecutor's on a jail call with like a jailhouse informant telling him like, oh, I just got to get Jeter, but she doesn't want to come, but I need her. So I'm going to find a way to make sure, I think it was to make sure she was unavailable and he didn't want her to be there. And the informant's on the other side of the recorded call like, you sure? So she has that recording and she filed a lawsuit. That came up on my radar. We're going to do a video on that because that's really interesting. Earlier this year, Graves told the Daily News that Sims killed the victim. This would have been earlier in 2021, remember? But Graves' 2002 statement said that he did not see who shot the victim and he didn't know who did, but that police had threatened to charge him with Chen's murder unless he testified against Sims. So, yeah, how is this allowed? The funny part is, like, you said this 3 minutes ago, but it could still apply to what we're looking at here. It's like a timeless question. Good to see you, Coke Fairy. We've got, let's see, the police, this is a quote from the 2002 affidavit. The police stated that if I do not appear tomorrow morning at the trial, they are going to release Anthony and charge me with the murder. So I appeared the next day and did whatever it was they wanted. And this is again on the tails of Hale saying any of the other testimony wouldn't matter unless I can get Graves. So you're acknowledging that he's your only evidence that Sims is the one that's guilty, but then at the same time you're saying, if we can't get Sims, we'll just go after Graves. Which is kind of an indication you don't think you necessarily have the right person. You just want one of them. This wasn't the only leverage the prosecution had against Graves. At the time of the trial, he hadn't checked in with his probation officer for close to 3 years. A few months after Graves testified, the Brooklyn's DA's office filed a violation of probation a few months before he testified. So 3 years, he hasn't shown up. But right on we're approaching this trial, we know we need him. Well, let's sow the seeds to make sure he knows this is hanging over his head. So they file a violation of probation and schedule a hearing on the matter for May 10th, 1999, the same day he testified at Sims' trial. Oh, man. After his testimony, however, the Brooklyn DA's office dropped the violation of probation. Yet when he appeared at trial, Graves testified that he was in court voluntarily and that he regularly checked in with his probation officer. It's perjurous. Despite his obligation to correct false testimony by witnesses, Hale did not challenge Graves' claims. According to Sims and his attorneys, Hale committed additional misconduct when he failed to disclose that the Brooklyn DA's office was paying for Graves and his family to enter a witness relocation program. In the year following Sims' trial, Graves and his family received more than $22,000. Dang, and that's like 1999 money. Graves did not respond to multiple requests for comment from New York Focus. Sims said he told his trial counsel that he saw Graves commit the crime and asked to testify, but that the lawyer advised him not to testify. Quote, I never got a chance to tell my story, Sims tells New York Focus. Sims' trial counsel has since died. Sims also says he told all of his appellate attorneys that he saw Graves commit the crime. His one surviving appellate attorney confirmed this to his current counsel. In a statement responding to question, and this current counsel, I'm assuming it's a team. We heard the one, Hiles, I think was the first name we saw. But there's another guy, his first name's Elon, like with an I. And since he got on this case, he has been like that side-by-side attorney, like he just has this burning advocacy, like he knows this was an injustice and has continued to stand there and fight. And I always love to see that. In a statement responding to questions sent to the DA's office by New York Focus, spokesperson Yaniv, characterized Sims' account as novel. And we got a quote, this case presents a number of disputed factual and legal issues which are appropriately resolved in a court of law and not in the media, the statement said. This is why our office consented to a hearing that would allow Mr. Sims to argue his claim of innocence before a judge, including a new contention not made in previous motions that his good friend was the alleged perpetrator and then conspired to frame him. So this pisses me off because it's like, Why are you going out of your way to specifying his good friend as if it's not credible that your good friend did this and you're saying he's trying to frame you? Why would your good friend do this? The reason that's so problematic is because Mark Hale's prosecution strategy was have Graves say that Sims did it, because Graves is the one that's willing to say Sims did it, and if he doesn't, we'll go after Graves, which would be the flip of the scenario. The other best friend did it. So either way, the idea that a good friend wouldn't turn on another and lie on them is something that the trial prosecutor seems to reject. But that's the statement they're getting from this office. So we've got, but at trial, Sims' defense counsel said that Graves, not Sims, was the perpetrator. In fact, Hale told the jury during closing arguments, "Now you heard the summation of the defense. Mr. Timms, who is the defense attorney, wants you to believe that Julius Graves is the perpetrator of this crime." In Sims' 2016 letter to the Conviction Review Unit, which he wrote himself without legal counsel, he said that he was innocent and included Graves' recantation, but did not say he had witnessed Graves kill the victim. In a statement through his attorneys, he told New York Focus that he thought if he accused Graves in the letter, it would just seem like I was looking for a scapegoat. He wrote in bold letters, "I am innocent," he said in a statement to New York Focus. He said, "I expect the CRU to interview me, which would give me a chance to answer their questions and give a detailed account of seeing Julia shoot the victim." So here's Anthony Sims in 2019, so a few years ago, but still like 2 decades after this trial. The CRU did not contact Sims to learn more about his claims. Instead, he received a 1-page rejection letter stating that it would not investigate the case because the evidence that you're asking the CRU to rely on has already been rejected by multiple courts. So, who reviewed the recantation letter? Sims' request to the CRU did not present any of the new claims that his attorneys have included in the current petition to vacate Sims' conviction, including evidence of Hale's misconduct and eyewitness testimony that Graves was a shooter. It was based almost entirely on Julius Graves' recantation of his testimony in 2002. So, Sims' trial lasted 5 days. After 3 days of deliberations, the jury sent a note to the court saying that they were deadlocked. The judge told them to keep going. The next day, the jury acquitted Sims of intentional murder and convicted him of depraved indifference murder. At his sentencing hearing, he professed his innocence. He said, "I know in my heart and God knows that I'm not capable of what I was convicted of. A jury of my peers found me guilty with the evidence that was presented to them and not the true facts." So he's like, I respect the jury's verdict, but it was based on some BS. At the time, his sons were 4 and 5 years old. His then-wife, Keisha Sims, said that she expected that he would be acquitted and had been planning a coming-home party for him. Oh. When he was convicted, she told New York Focus she thought it was the end of my world. Damn. Yeah. So, now let's get into some tea. A fun time record of misconduct. Also, I see Adventure Aaron here sharing a link in the chat. You guys, thank you. The study that was, I think this was the Page Not Found, Judging Innocence by Brandon Garrett from Columbia Law Review 2008, and New York Times still has a live link, which Aaron just shared, so thank you. Thank you. All right, so Sims' experience wasn't an aberration. From 1990 to 2013, the Brooklyn DA's office was run by Charles Hines, under whom more than 100 people were wrongfully convicted, in some cases serving decades in prison before being exonerated. Crazy. In 2013, controversy over Hines' tactics helped Kenneth Thompson defeat Hines. After taking office in 2014, Thompson expanded the Conviction Review Unit, fulfilling a campaign promise and earning a wave of laudatory national media attention. Thompson recruited Harvard professor and former public defender Ronald Sullivan to lead the unit's efforts, but Mark Hale, the prosecutor from Sims' case, was charged with supervising the unit's day-to-day activities. Hale had a record of alleged prosecutorial misconduct dating back to the 1990s. As deputy chief of the Homicide Bureau under Hines, Hale participated in an office-wide practice of deceiving judges in criminal cases, witness coercion, and intentional suppression of evidence, according to a federal lawsuit recently filed by exoneree Emmanuel Cooper. Cooper was imprisoned for a 1992 murder of a subway token clerk. last year, a New York Supreme Court judge, and remember in New York, the Supreme Court is like the trial court, not the highest, like, state Supreme Court. It's stupid. It's stupid. Several months later, the DA's office dismissed the charge. He served more than 25 years in prison for a crime he did not commit. Hale was a trial prosecutor. According to Cooper's civil complaint, 2 eyewitnesses said they recognized the assailant and that it was not Cooper. 2 additional witnesses did not identify Cooper from a photo array. Cooper's appellate criminal defense attorney and civil attorney is Tom Hoffman, who is the same person representing Sims. 1 witness for the prosecution, who was under arrest for an unrelated attempted murder, repeatedly told police he had no information on Cooper's alleged involvement in the murder. According to Cooper's civil complaint. He only implicated Cooper after police told him his charge would be dropped if he cooperated. 3 weeks later, all his charges were dropped. So he cooperates, and just like that, it's the magic wand. It's a magic wand. Later, when he tried to recant, investigators with the DA's office told him the DA would pursue the attempted murder charges if he disavowed his earlier statement. Very, very much a hunt for the truth. They want the truth so badly, don't they? They really want to know what really happened. They want to do prosecutions the right way. They want to make sure they get the right person. Doesn't this all just give you so much confidence? Hale disclosed none of this to Cooper's defense counsel, according to Cooper's civil complaint. Cooper said he felt he could not have the CRU review his case when Hale was running it. Mark Hale's not going to fix his faults, he told Focus. He did so much damage to everybody. After dismissing the charges against Cooper, Brooklyn Supreme Court Judge Ruth Shillingford called for an independent investigation into the circumstances that led to his wrongful conviction, saying, "There's got to be an evaluation of what happened in every case. How did it get to that point? And that cannot be done by the district attorney's office." So you've got a judge here that going beyond a ruling is like, we need to look at this more. Here's a picture here. This is, again, some support, some advocacy in relation to Sims' wrongful conviction back in 2021. Here's another. Hale prosecuted Vladimir Campos, who was 22 years old, for the 1997 murder of 16-year-old Felix Gonzalez. During trial, a state witness testified that police had coerced him into implicating Campos, that he had later recanted his statement to Hale, and that he had failed a lie detector test. When questioned by the trial judge after the witness's outburst, Hale initially denied. The judge at this trial questioned the prosecutor. Oh, I wish we could see this. This would be so cool to watch with, like, 1997 footage. So the judge is questioning Mr. Hale. Hale denies any knowledge of a lie detector test. Then 2 days later, he told the court that he had, in fact, ordered the polygraph. He ordered it himself! And helped formulate the questions. What made him realize that between 2 days? Can you imagine? Can you imagine if this was a defense attorney being pressed by a judge and the Law and Crime Chat got to watch the defense attorney get called out for lying, and the defense attorney had to come back with their tail between their legs 2 days later, like, yeah, I actually ordered that thing and prepared all of it, even though I said I had no knowledge of it 2 days ago. Like, we need that type of ripping. We need, like, a Law and Crime, but with a chat that rips this type of stuff apart. So Prosecutor Hale had also falsely told, that's not the only thing wrong in this trial for Campos. He falsely told Campos's trial counsel that the witness had never recanted. The judge admonished Hale for committing prosecutorial misconduct. She struck the witness's testimony but allowed the case to proceed. Campos was convicted and sentenced to 25 years to life. I'm sure that there are hundreds of other cases just like mine, Campos wrote to New York Focus from prison. I'm sure that someday all of it will be exposed and many people will have their day in court again. And Campos here, a lot of these individuals who've experienced this are advocating for those that are still stuck behind them, which I think is awesome to see. We recently saw that with, I always forget the guy's name. His name starts with a J. But he was an inmate with Alan Porter. He studied law, and he won his own release And now that he's licensed, he has a law license, he's been advocating for others, including his then inmate, Alan Porter, and Alan Porter's conviction was recently overturned and he was released. So I always love to see advocacy like that. I wish I could think of his name. I feel like in 2 seconds, Aaron's going to be like, actually, I think, hold on. Maybe I have it on the quick. Jabbar Collins. It's Jabbar Collins. All right, so next here we have an inherent conflict of interest. We're going to get a quote from someone calling it that. Yeah, look, there's, yep, right there. I beat you, barely. But I knew you would be there. I knew Aaron would be there. The magic 8-ball of the chat. So we've got conviction review units have exonerated more than 500 people from across the country. From 2014 until Thompson's death in the fall of 2016, Brooklyn's unit exonerated 21 people. So I think this is more of a testament, not that they want to exonerate people, but that they had such, what is it, they said up above, like 100 cases that needed to be reviewed. So they just had so much that they needed to review with a strong basis, and you have these judges saying that, yes, you engage in prosecutorial misconduct. Yes, there's an inherent conflict of interest. So we've got, during DA Gonzalez's tenure, 9 people have been exonerated. In April, the CRU also moved to vacate 90 convictions based on the testimony of disgraced NYPD narcotics detective Joseph Franco. 90 convictions. Maybe we'll have to deep dive on let's just read this. Let's do a side story. So April 7th, 2021, this is a press release, an immediate release from the District Attorney of Kings County. Brooklyn DA Eric Gonzalez to dismiss 90 convictions that relied on former narcotics detective, later charged with multiple perjuries. Whew. Well, love to see it. Former Detective Joseph Franco is awaiting trial in Manhattan. No misconduct was found in Brooklyn, but DA's office has lost confidence in cases where he was essential witness. And they say Eric Gonzalez today announced that his conviction review unit will be asking the court to vacate and dismiss 27 felony convictions and 63 misdemeanor convictions that were directly based on the work of former undercover New York City Police Department detective Joseph Franco. The former detective has been indicted in Manhattan for perjury, official misconduct, and other charges in connection with 4 incidents whereby he allegedly framed numerous individuals for making narcotics transactions. A review by Brooklyn's CRU did not uncover misconduct, but the district attorney has lost... I mean, did he not have direct involvement here? How do we have, like, a 0 versus, like, 100? A little sus. But the district attorney has lost confidence anyway in cases where the detective was an essential witness, cases that could not have been prosecuted without him, and is requesting that those convictions be dismissed. So DA Gonzalez said, knowingly and repeatedly framing innocent people obliterates the credibility of any police officer, and proving perjury in such circumstances is rare. After a grand jury reviewed the evidence and indicted former Detective Franco, I've lost confidence in his work. I mean, I feel like he has to say that, like he's got to wait and say, like, I can't jump to that conclusion until I have a reason to say so, but it seems a little odd. Like, I didn't lose confidence until a grand jury decided. His cases in Brooklyn are over a decade old, which limited our ability to reinvestigate them. Okay. But I cannot in good faith stand by convictions that principally relied on his testimony. Integrity and credibility are at the heart of the justice system and prerequisites for community trust. So now they're asking the Brooklyn Supreme Court to vacate these cases that we heard about above. All but one of the 90 convictions were obtained by way of a guilty plea. Most of those convicted for a felony were sentenced to between 6 months and a year in jail, with the longest sentence being 3 years in prison. Most of those convicted for a misdemeanor were sentenced to terms ranging from time served to 90 days in jail. Wow. All but one of those 90 convictions was obtained by a way of a guilty plea. So he was indicted on 16 counts of first-degree perjury and related charges. In July 19, a grand jury indicted him on 10 additional counts of first-degree perjury and related charges, and he was awaiting trial at that point in time that they published this press statement. Oh, is this just a live link? This will probably just take me to a live link. Yeah, this link was going to take... So they added a note to this that there was going to be court proceedings that you could watch live, but it was only live. There's no replay at that link. So that might be another rabbit hole to go down in detail at another time. We've got, let's see, conviction review units. We've read this. Defense attorneys point to Hale's control of the unit as a key reason for the slow pace of exonerations. New York Focus and the Appeal reported in May. I wonder if that's the report. I will find... Oh, yeah, I think this was it. So I'm going to share this article in the chat. I'll have to update the description with it. But this is what sent me down a rabbit hole. And I didn't find this in 2001. I found it more recently, like within the last 2 years. But this story, a Manhattan DA candidate touts her leadership of a conviction review unit. Yay, I'm so good. Why did it exonerate so few people? Because I'm so good. I'm keeping everybody convicted. So this is what started. Let me link to this. And when I was reading this, this is let's see. Is this the report? Oh, there's a ton of links. So I'm just going to link to this because all the links are within it. And I'll have to update the description with this link. But that is like how I initially heard about Sim's case, was starting to look at this data that New York Focus and the Appeal were putting together. So tons of stuff to look at there, you guys. We've got, let's see. Oh, here, Jabbar Collins. There's his name. Here he is. So CRUs are tasked with investigating convictions secured by their own offices, often the colleagues, friends, and supervisors of CRU staff. To Jabbar Collins, this is who we were just talking about. He was incarcerated. He fought his conviction, and then he started advocating for others when he got out. His name came up in his advocacy for Alan Porter, who recently had his conviction overturned. So shout out to him. What an awesome thing to do, to lose so many years of your own freedom and then to spend the years that you are free making sure you're not leaving anybody behind. So according to him, that conflict of interest makes it imperative that a CRU is led by someone outside the office. Collins was wrongfully convicted in 1995 in Brooklyn. His own investigation led to his exoneration in 2010. If the true focus of the CRU is to do justice, you need someone who's not going to get everything from a prosecutorial perspective and look at ways to save the conviction. So don't look to the law and crime chat, said Collins, a legal analyst with Horizon Research Services. Elizabeth Felber, supervising attorney for the Legal Aid Society's Wrongful Conviction Unit, said she hopes to head the next head of the unit. Hill's replacement comes from the defense community. Hold on, let me get a drink for 1 second. Oh, almost took me out there. All right, so there we go. They want, let's see. The new head of Brooklyn's Conviction Review Unit should be someone with no prior connection to the office in order to avoid any conflicts of loyalty or unconscious bias. So, I don't have any conflicts of loyalty. Well, maybe you don't even know. Felber told New York Focus in a statement, ideally, the new head should have a criminal defense experience to be able to bring fresh perspective to the unit. In statements to the press, the Brooklyn DA's office has claimed that Hale did not review Sim's case. But this is not enough to protect an applicant to the CRU from an inherent conflict of interest. Heck yeah, because if you work alongside somebody and you've got to work alongside them tomorrow, and if you trust them already, you might have inherent trust in them that would lead to an inherent bias, a certain lens through which, oh, he worked this case? I don't think that he would do something wrong. And then you're looking at this application through that lens. That's a conflict of interest. Let's see. Okay, and Collins met Sims 25 years ago. So Jabbar Collins actually met Anthony Sims 25 years ago while they were both incarcerated in New York. So they were also fellow inmates. So Collins says, I think that's a farce. Even if he was not part of the review process, you're still asking a subordinate to make a finding about his superior. Conviction review units, said Sims, should not even be housed in prosecutors' offices. They should be an entirely independent agency, totally separate from any DA's office. A lot of prosecutors know each other, he said. They don't want to hurt their friends or make their friends look bad, so it's easy to sweep things under the rug. It's easy to rubber stamp things. And this is so golden. This is such a golden quote when we consider that little quick statement we had from Yaniv up here. Where was that? Let me just search the name. Yeah, Yaniv said, "This is why our office consented to a hearing that would allow Mr. Sims to argue his claim of innocence before a judge, including a new contention not made in previous motions, that his good friend was the alleged perpetrator and then conspired to frame him." Like, if we're going to put some emphasis on friendship when it helps us keep convictions, well, we need to consider how relationships within the office, whether it's platonic or it's a power relationship, how that could impart the lens through which a conviction review unit would look at something. So we were here at a sad injustice. So Sims was 24 when he was convicted. At the time of this writing, he was 46, so he's probably like about 50 now. Before the murder, he said, "I had everything going for me. I remember looking forward to coming home because my sons would hear me in a hallway. I would just hear them screaming, 'Daddy, Daddy, Daddy.'" So that's the age that he was taken away from his kids, is when they're still, I know some people don't ever change the name they use for their parents, but young kids. And then closer to your release, he's obviously still incarcerated here, but you can see that in 2015, they're already grown. Already grown. When he went to prison, his wife Keisha brought their children to visit every weekend. Occasionally, the family stayed together in a trailer on the prison grounds. "I always just wanted to run in the back and just run with my dad and just hide. Like, 'Dad, I'm staying with you,'" Anthony Sims Jr. says. He was 27 at the time. Sims and Keisha divorced in 2018, but they've remained close friends. Sims has since remarried to... Oh, that's why I'm... All right, so when I was reading this, I was like, how do you spell Keisha? Because this is now with just an I, and earlier I'd seen it with an E. So Sims remarries to his junior high girlfriend, Keisha with an E, Sims. All right, so we've got two Keishas. My bad on that one. Not only was Anthony's life taken and he was ripped from his family, but the victim never got justice, Keisha told New York Focus. "It's just a sad injustice all the way around." Keisha and Keisha love that both of them are, like, isn't that cool? They're not going to do a Caroline to Angela type thing if you were watching the Cole Goldberg trial. They're going to be like, "Hey, this is wrong. What happened here to Anthony is wrong." So Keisha and Keisha, along with Cooper and Collins, there's a lot of alliteration, are championing Sims' innocence. "I want to support him now because he's another one of the many individuals that's in there for something he didn't do," said Cooper. Sims, again, that was the other inmate where we read his wrongful conviction story above. Sims' attorneys have filed a petition to overturn his conviction, but the judge hearing their case, Danny Chun, has never reversed a conviction during his 16 years on the bench. A hearing before Chun is scheduled for next month. So, yeah. I wouldn't have my hopes up if this was me happening to hear this in real time. A new review by the CRU under a different director may be Sims' best chance at exoneration. Sims is no longer angry with Graves. This is so powerful. He said he forgave him years ago during a family visit. When Anthony Jr. was about 8 years old, Sims recalled, he told his father that he would get Graves for what he'd done. Sims told him he couldn't think like that. His son began to sob. And Sims says, "It was at that point I forgave him. I had to forgive him because I didn't want to walk around bitter." So he sees his 8-year-old son, like, angry. "I'm going to get this guy Graves because what he did to you, Dad." And Sims just has this moment where he realizes he's going to decide to give grace to the man that put him in prison. So, and then he assures his son, everything's going to work itself out. The truth is going to come out eventually. So pretty excited here because that's where we're going to eventually get to with the stream. Next up, for some more context, back in the day here. So now we're a few months after that article was written. We're in February of 2022. And again, we've got prosecutor Mark Hale, but this is during the post-conviction relief hearings. So a wrongful conviction hearing puts a heralded Brooklyn prosecutor on the stand. I tried looking for a video. I couldn't find one. You know, I would have loved to watch a prosecutor on the witness stand. But Mark Hale, who himself led Brooklyn's wrongful conviction unit, faces tough questions about what he knew and when during the decades-old murder trial of Anthony Sims. So this is by George Joseph for the City. In 1998, Anthony Sims was accused of walking in, and we know the background. We're going to keep going. Prosecutors argued Sims had, after a night of drinking, shot Chen because of a heated altercation over a food order months earlier. After 4 days of deliberations, that's some context. Months earlier. Months earlier. What? After 4 days of deliberations, a jury voted to convict Sims of depraved indifference murder. He was sentenced to 25 years to life and remains in prison to this day because he hadn't been paroled yet. He'll be paroled in December of the same year. Now, over 22 years later, in a contentious wrongful conviction hearing revisiting the case, former Brooklyn prosecutor Mark Hale, who led the state's efforts, says he has no memory of the case he brought against Sims. Are you guys rating us? Hey, Prince of Wales. Good to see you. Good to see Darth Vader. Good to see you, Nefarious Shenanigans. I love that name. We are going through the storyline of the wrongful conviction of Anthony Sims, convicted because of prosecutorial misconduct over a Bushwick murder from 1998. And we're still looking at his initial post-conviction relief hearing. We're going to get all the way through his appeal and the oral arguments and the opinion, which overturned his conviction yesterday. So good to have you guys. Good to see you guys. A raid for a raid. That's right, Broken Baker. Let's keep it going. Yeah. And yeah, the initial theory was that this all happened because there was a fight at a restaurant after somebody ordered their chicken. It's a Chinese takeout restaurant, and the chicken was undercooked. The chicken was raw. So there was apparently a fight, and then the prosecutor's theory is that months later, the same guy that was supposedly mad about raw chicken comes back and shoots Chen at the restaurant. So it's a lot. It's a lot going on. It is a lot going on. So we're talking about post-conviction relief hearing. The trial prosecutor was put on the stand. For the last 15 minutes or so, we were reading other instances of the same prosecutor's history of misconduct in different cases. So now we're talking about Sims and the role Mark Hale played in this prosecution. So in a contentious wrongful conviction hearing revisiting the case, former Brooklyn prosecutor Mark Hale, who led the state's efforts, says he has no memory of the case he brought against Sims. Hale says he doesn't remember Chen, the victim, who Sims allegedly left to die in a spring night in Brooklyn. He says he does not remember Julius Graves, Sims' high school friend who was at the restaurant, whom Hale called to the stand to testify against Sims. He says he does not remember his closing argument, though it helped send Sims to prison. That's what Hale, who led the Brooklyn DA's wrongful conviction unit until his retirement last year, told a court on Wednesday during a hearing in which Sims' attorney tried to get to the bottom of what Hale knew and when he knew it. For more than an hour, as one of Sims' attorneys grilled him, Hale repeated variations of the go-to refrain, "Sir, I have no memory of this case." Today, Sims, who didn't testify at his original trial, says that Graves was the real killer, an argument his original defense attorney tried to make for him at the time. Sims' current lawyers argue that Brooklyn prosecutors deprived their client of a fair trial by failing to turn over evidence that would have implicated Graves and bolstered the defense's version of the events leading to Chen's murder. The actions or inactions of Hale and his colleagues go to the heart of Sims' ongoing challenges to his decades-old guilty verdict. During the original trial, Sims' attorneys were never told about an alleged eyewitness whose story undermined that of the prosecution. The witness initially told police she'd been unable to see anything, according to an NYPD report. But in a court hearing earlier this month, she said that eventually before the trial, she called a detective and made clear that she saw Graves, not Sims, running out of the Chinese restaurant with a gun. This purported call was not documented in any police records at the time, but an NYPD report from the investigation did memorialize an interview, which Sims' attorneys say corroborate the witness's present-day account. The report refers to the witness's claims that Graves, not Sims, was the person who shot Chen. Sims' attorneys contend that the NYPD document was never turned over to Sims' defense team, who were thus unable to reach out to the witness and put her conflicting testimony before the jury. And can you imagine, like, oftentimes we have situations where the police don't do the work and then the prosecutor's just like, well, we can't go fix that now. But now it's like the police actually did do something and the prosecution's just like, oops, we ignored it on purpose. It was an accident on purpose. At the hearing more than 22 years later, Hale said he had no memory of the witness, making it impossible for Sims' defense attorney to ascertain if he knew about that undisclosed police report at the time. Because of the alleged lack of memory, and I love that they keep saying alleged lack of memory, Hale also evaded potential questions about actions by the Kings County District Attorney's Office, which Sims' attorney argued unfairly inflated Graves' credibility. I don't think this journalist thinks Mark Hale's testimony was credible. Graves was also a convicted felon on probation for handgun possession. For 3 years, he'd violated his probation. This is the kicker. We heard about this earlier in the stream, but if you guys just got here, here's interesting stuff about the key witness, Graves, who seems to possibly be the actual shooter, who testified at trial that Sims was the guy. Graves was a convicted felon on probation for handgun possession. For 3 years, he'd violated his probation by failing to report and fill out paperwork for his probation officer. Sims, on the other hand, and they're gonna... Let's make sure they get the context, but if they don't, I'll come back to this point. Sims was an engaged father of 2 with a steady job and no criminal record, according to a recent memo filed by his defense team. But prosecutors did not disclose this information to the defense at the time, according to a court filing by Sims' current lawyers. At the trial, Graves falsely testified that he'd reported to his probation officer often and regularly. Sims' attorneys point out that Hale failed to correct this testimony, even though Hale's answers at Wednesday's hearing make it impossible to know if he was aware of Graves' history at the time. In response to a question about the alleged false testimony, a spokesperson for the Kings County District Attorney's Office noted that prosecutors did not get a chance to prepare or speak to Graves before his testimony because he took off to North Carolina before being brought back to testify. Sims' then-partner admitted in a sworn statement that she paid the bus fare for Graves' trip, causing the trial to be suspended until his return. Years after his time in the District Attorney's Homicide Bureau, Hale went on, all right, we're going to get this context. We're going to run it back because I think it was so critical about this probation. All right, so Graves, key witness. They have to get this. Hale, he ends up saying, it's my belief Graves will indicate that he in fact saw the defendant shoot and kill the deceased in this case. As the court obviously has seen, I have nobody else who said that. Any of the other testimony wouldn't really matter unless I can get Graves. So Hale, back in 2 decades ago, before this trial, was begging the judge to issue a material witness warrant to make sure Graves would show up for trial, make him show up. So Hale gets this witness warrant. He also gets one for Graves' fiance, even though she wasn't called to testify. Graves only agreed to testify after his fiance was arrested, so they arrest his fiance. Crazy. In 2002, he recants his statement. That's just some additional context there. In that affidavit, he says the police stated that if I do not appear tomorrow morning at the trial, they're going to release Anthony and charge me with the murder. So I appeared the next day and did whatever it was they wanted. And then this wasn't the only leverage that they had. At the time of the trial, he hadn't checked in with his probation officer for close to 3 years. A few months before Graves testified, the Brooklyn DA's office files a violation of probation and scheduled a hearing for the matter on May 10th, 1999, the same day he testified at Sims' trial. After his testimony, however, the Brooklyn DA's office dropped the violation of probation. So yeah, very critical context. Would anyone disagree that they didn't care about this guy being on probation and not reporting for almost 3 years until they realized that they would need him to prosecute somebody? And then they schedule a probation violation hearing for the same date that they need his testimony. And then they drop it. They drop the probation violation. It's just gamesmanship. Just gamesmanship. Coke Fury is asking about beer can chicken. Never had it. Never had it. Oh, man. We've got years after his time in the District Attorney's Homicide Bureau, Prosecutor Hale went on to lead the office's conviction review units. That's when he starts reviewing his own office's convictions to see if they were good convictions. In 2016, Sims applied to that unit to have his case reinvestigated. His application was rejected, and we read about this earlier in the stream. And then I'm clicking things. In the wintertime, we find out that there's going to be a parole hearing. So Sims, he's had good history while he's been incarcerated. And let's see. Actually, let's read this. This isn't about Sims, but around the same time period, October 12th, 2022, we have this context that Brooklyn District Attorney Eric Gonzalez says he's going to dismiss 378 low-level convictions linked to 13 former NYPD officers found guilty of misconduct. Oh, there's a lot of mess. A lot of mess was going on here. Here, I think this article, I just wanted to get the timeline. Here we go. There we go. So we end up getting some statements from this article, which is why I wanted to get into it. From his 1998 arrest for a Bushwick murder through his parole hearing this past summer, Sims has never wavered in asserting his innocence. Sims' stellar record while in prison enabled him to gain parole on his first attempt, and he will be released in November. Sims now hopes to replicate fellow Brooklyn exoneree Derek Hamilton, John Bunn, Sunday Moses, and Gerard Domint, all of whom saw their convictions overturned while they were on parole. So we got a quote here. So Anthony should not have been in prison in the first place. This is from exoneree Jabbar Collins. He was there at the parole board. He spoke to the parole board advocating for him. And let's see. Brooklyn State Senator Julia Salazar, in whose district the 1998 murder occurred, also expressed both strong support for Sims' parole and serious doubts regarding his guilt. Salazar noted that she is convinced that Anthony did not receive a fair trial, in part due to the improper withholding of exculpatory information and evidence by the state prosecutors. So that's a state senator there. There's never been any dispute that along with his friend Julius Graves, Sims entered a Chinese food restaurant, and the counterman, Mr. Chen, was then murdered. Sims' legal team contended that Graves, not Sims, shot Chen. According to Graves' girlfriend, testimony in the recent hearing, Chen had made unwanted sexual advances toward her on the day of the murder, making Graves angry at Chen. So here we get a different story, a different reason, and it would have been Graves would have the reason, as opposed to Sims is mad about a bad order from 4 months ago. Because that was the prosecutor's theory. The hearing also focused on evidence not provided to Sims at trial regarding an eyewitness whose claims that Graves was the killer show up in a police report from the time. As The Independent reported, Julius Graves has provided multiple different accounts of what happened at the crime scene, testifying at trial that he was inside the storefront when the shots rang out, but stating under oath last year that he was outside. On the stand last fall, Graves admitted to 2 lies during his original trial testimony, including that he'd been meeting regularly with his probation officer. In his September summation, Sims' lead attorney, Ilan Mazel, declared that Graves is a serial pathological liar. Ilan Mazel showed that trial prosecutor Mark Hale, former head of Brooklyn's Conviction Review Unit, made Graves' claims central to his summation. So this is a quote from the trial, from the prosecutor. Ladies and gentlemen, Graves was inside the store and he saw Sims fire the shotgun. In a recent hearing, Hale claimed to remember nothing about the case. During his 2 appearances last fall, Graves gave 2 different explanations of where outside the restaurant he supposedly was. He has no respect for this court, Mazel said of Graves. He has no respect for the truth. The packed courtroom included prominent exoneration advocates Jeffrey Deskovic. I think he just recently secured an overturned conviction. I think we talked about it. I think it was 2 guys. Or was it the Madison or Times Square shooting? I think it was a Times Square shooting. I think from the late 80s. He got that overturned like a year ago. I'm pretty sure that was him and his team. Elizabeth Felber and Derek Hamilton, each of whom told The Independent that they viewed Mazel's summary as devastating. Brooklyn ADA Ernest Chin, that's a crazy name, I have a very earnest chin, responded by deriding Sim's team claim as a massive conspiracy. I'm picturing this guy with a giant chin saying, "No, the defense team's lying. It's a conspiracy." He called the testimony of one of Sim's key witnesses a concoction. Julius Graves, Chin insisted, had remained consistent in his account from trial through the recent hearing. Chin further presented Graves' conflicting statements regarding his location at the time of the shotgun blast as understandable. Julius Graves was watching a murder that Sims perpetrated. He wasn't watching where his feet were placed. In response, Mazel observed that it's kind of remarkable that the DA's office would rely on a serial perjurer as their main witness. And as he reminded Judge Chun, the jury never heard about Graves' anger toward the victim as a motive. So they never knew that there was, the girl Graves was dating was improperly or inappropriately touched by the guy, like that day. Oh my goodness. During the trial, Sim's defense attorney told the jury that Graves committed the murder. Upon conviction, Sims then met with parole officers for a pre-sentence report. As the report summarizes, Sims stated that he was asked by a friend to go with him to a Chinese restaurant and that the friend shot the deceased. Unlike Graves, Sims has thus told the same story from day one. And then they're over the moon about the parole status. This is Keisha Sims, Anthony's current wife, and #1 advocate, but we'd rather celebrate his exoneration. So again, they're glad that he's going to be released, but they're going to continue to fight to clear his name, to get rid of the conviction. So in December 2nd, I saw this article. That's why I said he was freed in December. But this is when he's actually released. It may have been November and they didn't publish this until the 2nd. But we have a couple little bit of quotes here. So let's see. In an interview with NBC New York's Sarah Wallace, we have Alan Mazel. Yeah, am I going to say this Mazel Tov? Alan Mazel, one of Anthony's attorneys, explained what led to his unlawful conviction. Quote, "The NYPD basically ignored any evidence that exonerated Anthony, and the most glaring example is when an independent witness saw Julius Graves exit the restaurant with a gun right after the shooting, told that to the police, and the police kept that information, apparently, to themselves. Prosecutors have labeled 2 witnesses who testified that the police fabricated interview reports as incredible and continue back to Graves' version of the events. Quote, "They seem to want to stand behind this man who has lied repeatedly under oath in different statements over the years, and it's frustrating." This is from Sam Shapiro, another one of Anthony's attorneys. And then let's see. Keisha Sims, we have a quote from Keisha Sims. She says, "She'll never stop fighting, not only for my husband, but there's a lot of other Anthonys out there." True. And then, remember, we have 2 pathways here at this point in time. We've got, can we do another application to the Conviction Integrity Unit to ask them to do a review? And then we've got this attempt for post-conviction relief in front of a judge that's never overturned a conviction in 16 years. So here's the update on that story. This came down, this was March 10th, 2023. This is Judge Chun denying the call for the dismissal of the conviction. I don't know if there's anything interested in this. This court finds that the defendant failed to provide clear and convincing evidence that the defendant is actually innocent. Therefore, the defendant's motion to dismiss the indictment on a finding of actual innocence is denied. Let's see. And there's Judge Danny. And then Sims spoke after this. He said the system's broke. I used to think the justice system was broke, but now it protects guilty people. It's like, I always knew it was broken, but maybe it's just an accident. And now he's like, no, I think it's working. He says, I lost everything. My family lost everything. But it's working as it's designed. He has this realization that this is the way they want it to go. They want to secure the conviction. And it's not just mistakes when they get it wrong. They're just too focused on the wins. So 2 years ago, Sims claimed that he was framed in the fatal Bushwick shooting. And this is the district attorney's statement after the judge's decision here. They say, our office consented to this hearing to allow all the claims and arguments to be heard in open court. After a lengthy and thorough proceeding, the judge issued his ruling, and we agree with this decision. Let's see. And then, let's see. Chun, in the last line of his decision, noted that the defendant has failed to meet the burden of proving any of his claims to vacate the judgment order a new trial or dismiss the indictment. Accordingly, the defendant's motion is denied in its entirety. And then we're going to watch a little video from Fox 5 that they have from 2023, just to give us a lay of the land.
About Sheldon Thomas, a Brooklyn man who was freed after being wrongfully convicted of murder, spending almost 20 years behind bars.
Yeah, but today it was not the same fate for Anthony Sims. A judge ruled against his exoneration for the murder of a Chinese immigrant in 1998. Ashley Rodriguez was in the courtroom as that decision was handed down.
The reality of the ruling that would prove Anthony Sims is innocent of a 1998 murder in Bushwick left him speechless, with tears streaming down his face inside the Brooklyn Supreme Court Friday.
Anthony is strong. He's been through a lot. He's going to get through this.
Denies the defendant's motion.
Judge Danny Chun found Sims and his legal team failed to meet the burden of proof required to clear Sims's name.
Strongly as I believe that I'm a human being standing here today, not only is Mr. Sims innocent, but he was denied a fair trial.
Sims says he was wrongfully convicted of the murder of 27-year-old Li Run Chen. Sims, a husband, father of two, and who held a steady job at Bell Atlantic, was sentenced to 25 years to life.
Frustrating. I used to think the system was broke. It's not. It does what it's supposed to do.
Crazy.
It protects the corrupt people.
Sims lost the last 25 years of his wife, and kids' lives. On parole, Sims can't travel. With his record, it's hard to find well-paid work. But he's using his frustration to fight for exoneration.
So although I'm free from prison, I'm mentally chained to the system. And it's a travesty.
Sims's legal team plans to appeal the judge's decision, but first, the court has to grant them permission. That could take months or even years.
So they granted that permission, and that's where, let's see, we're gonna get into that. We'll do the oral arguments first, but just so you guys know, the written opinion in New York, whenever I look at like Court of Appeals decisions in New York, they're always like less than 10 pages. They're not these like 50 pagers that we get from other appeals courts. So nice and short. Captions. This is the court website uses Wowza Player. So I'm not really going to be able to go back very easily if we want to look at a facial expression or something. We're not really going to do that, even though that's really fun. It takes like 10 seconds to reload anytime I touch the player. So let's just see if we can not be a Pawsy McPawserton.
Without any follow-up.
Oh, this is quiet.
To protect the judge or members of the bar.
Your Honor, I can't speak to whether there was any follow-up in the abstract.
This is the previous case. This is the previous case. If I scrub it, it'll take a minute to reload.
There's no evidence of follow-up on this record.
But it's the end of it.
I don't know what steps the NYPD or court staff may have taken.
Thank you.
Thank you.
Both.
Dang, Aaron's got crazy weather.
The following matter is People versus Sims. Anthony Sims.
This was January 13th of this year, 2026.
Good morning, and may it please the court. Ilan Mazel for Anthony Sims. Anthony Sims served over 24 years for a murder he did not commit, and now the prosecution has collapsed under a mountain of new evidence and a series of Brady violations that the jury never heard. At trial, the case rested on Mr. Graves and a single independent witness. Now the independent witness has recanted and testified.
So the ID was based on the single independent witness, right? But then there was some corroborative evidence.
It was Mr. Graves, who was the murderer, and it was Shalima Rodriguez, who was the woman across the street on the second floor at night who testified that the taller man had the gun. She's now testified, she's recanted that testimony, and at length at the hearing, and told the court that she could not see the physical characteristics of the gun. I'm sorry, of the gentleman running from the restaurant. And again, that's evidence that the jury never heard.
Justice Chin did a very full decision on this case and didn't seem to feel that it was a proper recantation, in as much as she didn't, I've read it, she didn't say no, I was lying, no, they actually told me that they have to put this in there to cover, to include additional facts. It's kind of like all over the place in her recantation. And you do have a DD-5, right? And her statement saying very clearly that the second person, the taller person, was the one carrying the gun.
So let's talk about Justice.
Yes, because that's, Rodriguez
Justice
was a
below-
neutral witness,
Sure.
right?
First, Justice Chen did not even cite, much less apply, the standard for recantation evidence, which is one of the 5 legal errors he committed below, each of which requires reversal. Didn't apply the test for recantation evidence at all. Didn't look at the evidence, the new evidence cumulatively as required by this court in Tanclef. Did not look at all of the Brady violations cumulatively and in their entirety as required by the Court of Appeals in Ouellette. Did not look at a test for recantation evidence. Applied the wrong test for prosecutorial misconduct, which is supposed to be a reasonable possibility test. Instead, he applied a harmless error analysis. So his entire legal analysis is suspect from the beginning, specifically with respect to Ms. Rodriguez. If we apply, let's just talk about what she said for a moment. She testified that she could not see who was taller, and that the police coerced her into coming up with a false story. Applying the actual Court of Appeals test.
Did she actually say those words?
R2287, quote, coming to my house, being able to tell me what to do and move me around, and the separation with my son. I'm telling you, I don't know, and you're insisting that I did, is pretty intimidating. She also testified that they obligated and intimidated her into false testimony. They separated her from her 4-year-old son when they took a statement, they took her from her home, and then at trial again, they again separated her from her 4-year-old son. So we know she's an independent witness, she's their independent witness, and she's now recanted. That's one of the factors. What she said is inherently believable. She's on the 2nd floor, across the street, at night, heard gunshots, is on her knees, looks out the window, few seconds. There is no way she could possibly tell who's taller and who's not.
So counsel, how do you explain the fact that she made this DD-5 statement and then at trial, back up, before the trial, she couldn't identify the defendant in a photo array, and even at trial in the courtroom, she could not identify the defendant. So how is it, using your words, that she was coerced by the police? How is that logical? She made a statement, and then if the police were coercing her so much, how is she unable to identify the defendant?
I think even the police recognized that if they claimed that she could pick out a defendant from the 2nd floor at night across the street, that would be inherently incredible. So the best they thought that they could fabricate, and she testified unequivocally was a fabrication in the DD-5, the best they could say is, well, she saw that the taller man had the gun. But even those detectives who had tunnel vision, who were focused on Mr. Sims from the beginning, even they were not willing to go to the final step of saying that she could pick him out of a lineup, which would be utterly impossible for someone in her position. And I should point out, not a single detective at the hearing, this was a 6-month hearing, not a single detective denied anything Ms. Rodriguez said about their coercion, about the tactics they used on her. No one came up to defend their conduct. And we know that Ms. Rodriguez was treated differently from every single other witness in this case. They didn't ask her to make a statement. They didn't take her to the writing ADA to interview her. They didn't take a video statement. They didn't take an audio statement. They didn't put her before the grand jury. Their own testimony, Detective Mooney, their lead detective, said that every single witness in a homicide case is interviewed by the DA. Didn't happen here. Why? Because she had nothing to offer the prosecution. It's highly suspect. Every single factor, recantation factor, inherent believability, her unequivocal, unimpeached testimony. No one contradicted what she had to say. On cross, she was steadfast. And I should point out that she had a private ex parte meeting with the DA, which was recorded, which I urge the court to listen to. We have a transcript as well on the record, where she had no counsel present. We weren't there. She had no preparation. And she told them exactly what she said at the hearing. 100% consistent with what she said at the hearing. Court below didn't even consider that. Court below didn't consider almost any of this. Didn't consider that this was an independent witness. And this is just Ms. Rodriguez. This is just one piece of the 440. Then we also have the Rachel testimony. This is bombshell testimony. This is a woman, and I should add about Ms. Rodriguez, this is a mother. This is a woman with gainful employment. This is a solid citizen. She has no incentive whatsoever to help Anthony Sims. Zero. She has no connection whatsoever to Mr. Sims or his family. She was their independent witness that they cited in summation 9 times, citing her testimony. 9 times. The jury asked for a readback of her testimony before they convicted. This was a case
So it's
of
important.
3 days of deliberations and an Allen charge. She was critical of their case. Now she's not only recanted, not only is she not a people's witness, she's now an affirmative defense witness who can testify about the lengths the police were willing to go to get testimony favorable to the prosecution. So that's just Ms. Rodriguez. The Rachel testimony. This is a woman who puts the smoking gun in Mr. Graves' hands. Literally puts the smoking gun in his hands. Second, she hears a shot. He runs out. She knows Julius Graves is a neighbor. He's running with the long gun.
But she doesn't see a second person, correct?
She's focused on the man with the gun. Now, we know that Anthony Sims was running ahead of, Anthony Sims was in the restaurant. He sees Mr. Graves shoot. He runs. And so she doesn't see anyone else on the street because she's focused on the man with the gun. We all know about the gun weapons effect. You focus on the man with the gun, and she knew him.
So people will argue that she had a subsequent beef with Graves or with the family, and then that's why now she's saying what she's saying. You want to address that?
Sure. There's virtually no evidence in the record that she testified that she had no problems at all with Mr. Graves. Mr. Graves testified that Rachel had no problems with him. The only problem was that she saw him with the long gun, and afterwards she confronted him, and he told her she's a BITCH, and she should shut up. And so that's the only conflict. And I should point out.
So she does say in her new testimony that she spoke with the wife. I forget her name. I'm sorry. And
the ex-wife, yes.
that she told her what she saw. So how is this newly discovered evidence?
No, she did not testify that she told Keisha, who was Mr. Sims' ex-wife, what she saw. Keisha had heard, the record reflects that Keisha had heard that Rachel was a potential witness.
With a grapevine.
Right. Called her up and said, please call the police, tell them whatever you know. She testified, Rachel testified, she never told Keisha anything about what she knew. Mr. Sims testified she had no idea what Rachel knew.
Oh, I've got to pause. Happy birthday, Mel. Happy birthday, Mel. So I know I said it over in Discord, but gotta say it over on the YouTube because that's, this is really our real home. So hope you're having a great, wonderful, wonderful day. Since it's Thursday, I hope you get to celebrate this weekend as well. Just wishing you the best one.
And then Rachel went to the police. She did the right thing. She called the police and she said it was Mr. Graves who had the long gun.
Didn't she say that she would be helpful? She would be helpful, but she doesn't want to testify at trial. Wasn't that basic?
No, she did not say that. She told the detective on the phone it was not Anthony Sims. It was Mr. Graves, and I know that. And the detective said, "Thank you very much. We think it's not, and have a nice day." And they never called her, and no one ever called her to testify. Defense counsel never even interviewed her. So
But the defense counsel knew about her because everything was handed over, including the DD-5. So was it perhaps strategic by trial counsel not to interview her because of the impeachability?
the only DD-5 defense counsel had, the only DD-5 they produced was the one where it said she couldn't see anything because she wasn't wearing her contacts. Years later, in a FOIA request, long after the conviction, the defense secured an additional DD-5 related to Ms. Winbush, where she said, Rachel said that she's going to pin it on Julius Graves. Of course, Ms. Winbush was the fiancée, later wife, who was really part of the conspiracy with Mr. Graves. So the defense did not know this. If they did know that Rachel had this bombshell evidence and Mr. Tim.
All right, so I kind of just assumed that a DD-5 was like some vague record, like report. But more specifically, because they keep mentioning one, the term DD-5 in New York refers to a complaint follow-up form used by law enforcement agencies, particularly the NYPD. It's part of a system for documenting investigations and is often associated with the Detective Division 5. So that's why it's called a DD-5.
Since the defense counsel failed even to interview her, that would have been ineffective assistance of counsel. That would have been, and that claim is part of our 440. But he didn't know. And they couldn't know because the DD-5 simply said, I didn't see what happened.
What is the DD5 exhibit, the second one that was obtained pursuant to the FOIL request? Can you pinpoint that for me, please?
I think that's at R 1311, I believe, Your Honor. The court below, and I should emphasize, this court in Tancliffe held that it is not bound by the hearing court's factual determinations and may make its own credibility determinations. The court below discounted Rachel entirely for two reasons. The first is because the court said that all this court has is Rachel's words 20 years after the fact. That is flat wrong. R 1761, questioning of Mr. Graves. Question, Rachel went to the police and said you committed the murder, correct? Answer, yes. Mr. Graves is the linchpin of their case. He's their prima facie witness, he's their star witness, he's their only eyewitness, and he corroborates now Rachel saying that she went to the police and pointed the finger at him.
So counsel, there's a detective Vesatoro, I think that's his name.
Yes.
And he completed a DD5, correct?
Yeah, yes.
And I believe the record reflects that he had some conversation with Rachel, or there's a contention that he had a conversation with Rachel, but the DD5 does not reflect any such conversation. Is that correct? That the DD5 that he completed does not reflect what the defendant thinks the DD5 should really reflect?
I'm not sure. I'm not sure about that, Your Honor. The DD5 I'm familiar with Rachel is simply the one where she's in the phone booth and she couldn't see what happened. I do want to add a couple of things on Rachel. Again, she's a 41-year-old mother. She's employed by the city of New York. She is an independent.
Excuse me. So did this detective make an effort to locate Rachel?
So at one point there was a conversation. This is what led to the DD5 between Rachel.
Vesatoro.
I think it was Vesaturo. I'm not sure, Your Honor, and I apologize for that. But Rachel did speak with, she testified she spoke with a detective. They came to her on a stoop outside, and they asked her for information, and she was not willing to speak with the police out there in public, and so she told them, I didn't see anything. Later, she came forward. And again, she's an independent.
So what did this detective record in the DD5 concerning his efforts to interview Rachel?
I'm only aware of two communications between the police and Rachel. The first is where they asked her, did she see something? And she said she couldn't see it. And the second is when she called the precinct. And when she called the precinct, we don't know who she spoke with. But we do know that the precinct had a policy, according to the lead detective, of not writing anything down when people make phone calls. That is Detective Mooney at R 1918. And that was another point that the court below got wrong. Said the court found it implausible that the detectives wouldn't have written down what she said. But Detective Mooney said they had a policy of not writing down anything the witnesses said, no matter what it was. That's R 1918.
With respect to conversations with civilians, correct?
Right. That's right. And she's a civilian. So,
Is there anything in the record regarding how they found Rachel as a witness? What led them to Rachel? Is there a DD5 or something indicating why they thought she had information?
I don't recall exactly how they found her in the first place. She was a neighbor of Mr. Graves. They were using a battering ram in Mr. Graves' home to look for him because he had absconded. In addition, her fingerprint was on the plexiglass in the restaurant because she went there afterwards. So we know she was there. And again, the jury never heard from Rachel. The jury never heard the recantation from Ms. Rodriguez. And I want to talk for a moment about Mr. Graves. He's the linchpin of their case. He now has 5 versions of where he was at the time of the shooting. He told the grand jury he was in the doorway. He told the jury he was inside the restaurant. He told the hearing court he was 5 feet outside the restaurant. And then he told the hearing court on the second day he was 17 and a half feet outside the restaurant by a parked car. And if that's...
There was a DD5 that was taken early on before, it seems before the gun was actually recovered, the same day, but earlier, which indicates, and this is to dovetail with what you're saying, that Mr. Graves told the police that he only saw the gun in the waistband of Mr. Sims once he entered the restaurant, or once they went into the restaurant.
Every time Mr. Graves opens his mouth, he has a different story because he's a serial perjurer, including by his own admission. He lied about not knowing where the gun came from. It came from his apartment, from his own relative. He lied about that to the jury. The jury never heard that. And the DA wants to prevent a future jury from hearing that evidence. He lied about the
Look at this guy back here.
36 probation violations that he had for 3 years. He testified that he reported to probation regularly and voluntarily. That was a flat-out lie. And there's no explanation for that. He was under the thumb of the prosecution. Prosecution never corrected the record. It was fabricated testimony. It was a Brady violation, and it was prosecutorial misconduct. They never told the jury that. And then right after trial, he's walked over, and all the probation violations are excused. And then they give him $22,000 in benefits, also undisclosed. I would suggest, Your Honor, that today, when we look at the case today versus where it was back then, now we have an independent witness who puts the gun in Graves' hands. It's dramatically different from before. Now we have a witness who gives Graves a motive. The motive is that the decedent had been flirting with his fiancée, which at the hearing, his fiancée corroborated. That's corroborated. Now we have another independent witness, Ms. Rodriguez, who would testify about the police coercion and fabrication of evidence.
Is there any indication that, as Mr. Graves testified, that his mother-in-law was spoken to, or there was a DD5, because she was at the scene? She sees him as he's walking, or sees them as he's walking toward the Chinese store, the Chinese restaurant. Is there anything in the record, as far as you know, and I'll ask the people the same question, as to whether or not she was spoken to? Because he did elaborate. He said she asked him, "What's the matter? You look nervous." She's there. She's at the scene. Is there any indication in the record that there was an interview of this witness?
So Ms. Boulding testified at trial, and she testified Julius Graves went into the restaurant, and then she heard shots. That was her testimony. And then people ran out of the restaurant. That was her testimony. And that's 100% true. Mr. Graves came in, took the gun out of his pants, and shot the decedent, and then ran out. I should also add that at this point today, there is no independent witness left who implicates Mr. Sims in any way. Nobody. So the entire complexion of the case has changed. And the question is, I would submit there is not a single jury in Kings County that would convict on this quality of evidence. But the test before this court is simply, is it probable or reasonably probable that a single juror would have reasonable doubt based on what they've heard? The first jury never heard about the benefits, never heard about the probation violations were excused, never heard about...
The benefits are understandable, right? You have a witness, in witness protection, right?
It was
alleged threats. I mean, I don't think that's your strongest argument, but...
Well, except the threats were contrived. So there was a threat assessment done right after the testimony that didn't even include the threats that are somehow now the basis for all the housing that he received. You know, they claim they put him in a shelter, they put him in a beautiful two-story house. This is a man who was a convicted felon, who was not employed then, is not employed now. He was an alcoholic, and this was a gift to him. He had a place to live for him and his family. Very generous place for over a year, I believe it was. So he's receiving benefits, he's receiving a deal, his 36 probation violations are excused. By his own admission, he took the gun home, because it was his family's gun, and he wiped the fingerprints off, and then he and his Confederates conspired to hide the weapon from the police. By his own admission, that's undisputed.
The two individuals in the car, one of them is his cousin?
Yes,
One is
Mr.
a friend of his?
Mr. Dalp is his cousin. Mr. Cologne, who was 14, was his friend. And yeah, they were part of this conspiracy with him. And by their own admission, they hid the murder weapon. All of that excused. Where's the charge for that? So the jury never heard almost any of the evidence that is now before the court today. And the only question was this a fair trial? And is Mr. Sims entitled to a new trial? Finally, a fair trial. He has fought for 28 years to defend his name. 28 years, he served over 24 years in prison for something he had nothing to do with. And Mr. Graves, the murderer, who testified in the grand jury 3 weeks after and therefore got immunity from the DA, will never be able to be charged, which is the other great tragedy of this case. That because of the DA's conduct, the murderers run loose. But they've compounded that tragedy
Look at the
by
state.
charging Mr. Sims.
Just sitting down here like,
Mr. Sims was engaged. He had a child. He had a job with 9X. He was about to get his union benefits. This man had everything to live for. He had no criminal record. He was not an alcoholic. None of these things that were the case for Mr. Graves, who was a felon for weapons possession, who was an alcoholic, who was unemployed, and who had a motive we now know, but the jury didn't know, to at least scare, in his own words, or if not scare, murder Mr. Chen. So this was a terrible tragedy, a travesty of justice. A terrible travesty of justice. And it's taken 28 years just to get to this point where we can have a hearing before your honors, and we can finally vacate this unjust conviction, and if the DA so decides, give this man a fair trial for the first time in his life. He's finally out on parole. He's working for the Ford Foundation, but he wants to clear his name. This man had nothing to do with his murder. He never had anything to do with this murder. From the beginning, he said Mr. Graves did it. He said it in his pre-sentence report. His lawyer said it in summation. He's been fighting for 28 years to clear his name. And the court should vacate the conviction on new evidence grounds, evaluating all the evidence cumulatively, which the court below did not, on Brady grounds, evaluating the evidence in its entirety, which the court below did not, on prosecutorial misconduct grounds, because there is a reasonable possibility that the court's failure to correct Graves' perjury contributed to the conviction. That's at least reasonably possible. And the Supreme Court in Glossop, the United States Supreme Court in Glossop v. Oklahoma, this is in our reply brief, held that they have to prove to comport with due process, the prosecution has to prove beyond a reasonable doubt that the prosecutorial misconduct did not contribute to the conviction. They cannot possibly do that. He was under the thumb of the prosecution, and the jury didn't know that either. So for all these reasons, Your Honor, I think my time is up. For all these reasons, unless the court has further questions, we ask the court to vacate this unjust conviction on all the 5 grounds that we enumerate in our brief, and finally get to justice. Thank you, Your Honors.
Thank you.
May it please the court.
I was so ready. I had to catch myself for a second there because I was so ready to be like, okay, now let's read the decision. And then I saw movement and I'm like, oh, wait, oh, yeah, they get to argue back.
My name is Solomon Newbort, and I represent the people.
Unfortunately.
Judge Chen is a seasoned judge. He heard from all the witnesses.
We know that he heard all the testimony and made his decision. Let's get to the merits.
So let's talk about Shalima Rodriguez. Shalima Rodriguez says this to the defense attorney when they're interviewing her. They sent her the transcripts, they sent her the DD5s, the police reports, and then they interview her. And she says, I didn't remember anything about a short guy or a tall guy or a build. I don't remember any of that, but it has been a long time. And when I read that report, the first one was in the courtroom when I testified. The testimony in court, and I was like, I can't believe I said that. I don't remember that. And then when I look at the police report, it looks like it's consistent with that. So I don't know. I don't remember. I don't remember saying that stuff. So she doesn't remember what she said at trial. Then she says, you know why I said what I said at trial? Because they pressured me, the police pressured me. She didn't even remember what she
Your
said.
adversary says they treated her uniquely, separating her from her child, and treated her in a completely different way than any of the other witnesses in this case. What do you say about that?
What I say about that is that she hardly remembers anything. There's not even a DD5 report that says that she was ever taken to downtown Brooklyn by the police.
Well, you have a case that's close. You admit that, right? It's either Graves or Sims, one or the other.
Correct.
Did this, right?
Correct.
No other eyewitness. So she, as a neutral witness, is your star witness if we believe what she said is so. Audio tape statements are pro forma in the district attorney's office. You bring down that witness and you memorialize what they have to say, because this witness was the witness in the case. Am I right? This is the one that you're relying on, because everyone else, for whatever reason, is lying about different things, whether they're lying about what they actually saw in the end, but it's very clear from the DD5s that there's contradictions all over the place. So your case is not very strong without Rodriguez. Why was she treated that way? Why wasn't she audio taped? And why didn't they memorialize in a way that you can assess exactly what she had to say?
Well, she wasn't interviewed because, remember, she didn't identify anyone. All she says is, I saw a tall guy with a gun. There was a shorter guy and a taller guy, and I saw the taller guy with a gun.
That was huge. That was huge, because otherwise you were left with just Graves, who has a clear motive if he's the shooter. It's huge that she's saying the taller guy had the gun. That's the defendant. You're not minimizing that, are you?
I'm not minimizing.
Well, you seem
that.
to be.
I'm not minimizing it that at trial she became an important witness. What I'm saying is that at the outset of the investigation, when they do these recordings and they call in the witnesses, she wasn't identifying anyone. She wasn't saying, I saw Sims, I saw Graves. She's saying, I saw a tall guy with a gun. So that's why they don't interview her. Plus, remember, the police ask her.
Without this witness, do you have a case?
Yes, because there's Graves, there's Dallip, there's Cullen, and
You're talking about the two people in the car?
Colin?
correct.
Well, but they're Graves' friends.
They were also Sims friends. One of them played basketball with Sims, and none of them had to.
But did they
frame-
hide the gun?
But also understand something. No one had to frame
Ask his question.
Sims to get Graves off, because without Graves,
It just skipped the question, right? Look at Elon. Look at Elon's face right here. Let me move myself and make him a little bigger. It's kind of a awkward zoom with this. He's just like kerfuffled.
there was no case against Sims or Graves.
Let me ask you this. The gun came from Graves' house, correct?
The gun came from Graves'
Okay.
house.
He claims that he had never seen the gun, right? Wait a second. But he claims, I think his testimony was, I think my father-in-law wanted to sell it, so he must have sold it to Sims, right? Something along those lines?
Right, he saw
Okay, so wait, what are the chances of all the people in the world that gun could be sold to, that it was sold to the person who Graves is accusing of this crime, and that after the crime, Graves would decide that he wants to take this murder weapon that he just witnessed Sims use back into his home and wipe the prints and hide it? What are the chances that this was not Graves protecting himself?
The jury heard all of that, and they heard all of what you're just saying.
I didn't hear Rachel, who said that Graves had the gun running out of the Chinese restaurant.
Here's what Rachel, here's the DD5 of what, Rachel says two things. Rachel says that the police came to her house and interviewed her on her stoop, and she said to them she saw nothing. Then she says she called the police and she told them that Graves had the gun. The DD5, from the day after the shooting, so the shooting is May 18th, this is May 19th, the police come to her house and she's not there. They give a card to her sister and ask the sister to tell Rachel to call and the precinct to contact the precinct. Rachel then comes to the precinct and she says to the police, and this is before the police would have had any reason to discount anything that Rachel is saying or to fabricate, because if they wanted to say that Rachel didn't see anything, they could say exactly what she said that she said to the police when in her hearing testimony. She says, I told the police that I saw nothing. So if the police wanted to say that she saw nothing, all they could say is that they went to her house, she saw nothing. But what the DD5 says is that Rachel was not home. Not that she says was on the stoop and said, I saw nothing. She wasn't home. They gave a card to her sister. She came down to the precinct. Rachel says she never, ever went to the precinct. There's a DD5 from the next day saying, the day after the shooting, she went to the precinct. She says, I was standing at the corner of Wilson and Decatur. I heard a bang, but did not see faces of a large group fleeing because I was not wearing my contact lenses.
Is it
Now-
unusual for a civilian witness to not want to get involved in a homicide investigation? The answer to that is it's not unusual at all, right? Is that the answer to that?
Well, that's correct. It's not unusual. But she's saying she never said that. She said she never went to the precinct. She said she never did. Her story is so completely inconsistent with a contemporaneous police report. She says that she was sitting on her stoop and the police interviewed her. The DD5 report from
What
the
do we
next
do with the fact that she claims she called the precinct and they weren't interested because it didn't comport with their theory of the case?
She said she called the precinct because Risha Tucker asked her, Rucker asked her to call the police. But that doesn't really add up because Rucker doesn't ask her afterwards, did you call the police? Doesn't tell the defense counsel or the defendant, according to the defendant, that Rachel has exculpatory information to
Your
offer.
adversary says that those people did not know what information she had.
Is it plausible that somebody who's a defendant's wife, newly wedded, who's trying to exonerate her husband, would ask somebody to call the police and tell them what they saw without asking them first what it is that they saw? Doesn't make any sense. Nobody would ask, call the police, tell them what you saw, without first saying, what did you see?
Well, it's clear that Miss, what's her name, Pumpkin, what's her,
Yeah.
Pumpkin?
that she's 17 years old, correct? And that she, from the beginning, really wants to dissociate herself. She lives in the neighborhood, she knows everyone.
Right.
Claims there's some sort of subliminal threat made to her ultimately. So is it plausible that she didn't tell the wife exactly what it is that she saw, but that the wife heard, she heard something, that she was saying something that might have exonerated her husband? But because clearly the 17-year-old was not being very clear. She wasn't being very open about what she saw. She clearly was in a position to see exactly what went down because she was within feet of the store, right? But she was clearly not forthcoming at that moment. Is there any reason why that you can discern why she would change her testimony now?
She never testified. And I would point out that in 2003,
Change her account now.
the defendant put in a 440 motion, and he said that he had exculpatory information from Rachel. He didn't say what the exculpatory information was from Rachel. He testified at the hearing that his wife told him, not before the trial, but after the trial, that Rachel had told him that Graves had the gun. Then when he realized that blunder on redirect, he then changes his testimony to say, no, I didn't know that Rachel was going to say that Graves had the gun. What I knew from my wife was that Rachel had exculpatory information, but that was it. But I didn't know about a gun. It wasn't until 2016 or so that I found out during the CRU investigation. So he changes the story at the hearing about, and it's clear, you can
Rachel's
see.
account now that Graves had the gun completely comports with Graves taking the gun out of the car and into his house, wiping it down and hiding it. That behavior in and of itself, I think you would concede, is remarkable, that someone who did not use a weapon, who witnessed a murder, would take the murder weapon out of the car into his house, wipe it down, and hide it. How do you explain that?
Well, for one, the jury heard that. That's not new testimony.
Yeah, but coupled with Rachel's
heard it.
testimony, you can break it down any way you want, but it's coupled with Rachel's account that Graves had the gun. So address it considering that.
I think that Judge Chen was correct in discounting what Rachel said altogether because it was completely inconsistent with the contemporaneous DD5 where she says that she was interviewed on the stoop and told the police that she saw nothing when the DD5 says she wasn't home. She says she never went to the precinct. There's a contemporaneous police report saying that she went to and said that she was not wearing her contact lenses and didn't see anything. She didn't have to say that she was standing at Wilson and Decatur and that she heard a bang and that she wasn't wearing her contact lenses. She could have said, I didn't see anything, like she says at the hearing that she told the police, I didn't see anything.
But clearly she was there, right? We can all concede that. She went up to the store, she left the fingerprint, right? She was there.
Correct, but the day after she went to the precinct, it's not like somebody was interviewing her at her home. It's not like the police dragged her to the precinct. She went on her own to the precinct and said, I was there, I heard a bang, I turned around, I saw a large group of people fleeing, I couldn't make out any faces because I was not
Look at
wearing my
Alon.
contact lenses. That's a level of detail that the police cannot have made up. She confirms at the hearing that she did have contact lenses, but now insists that she was wearing her contact lenses.
There's no question that she wasn't forthcoming, right? I mean, she didn't go there, oh, I want to tell you what's going on. She was told to come down to the precinct, 17-year-old, right?
Right, but she went down and she tells this story, but she's denying at the hearing that she ever went to the precinct. Instead, she tells a completely different story, saying, I called the precinct and said it was Graves. And then on the phone call, a detective not only doesn't write it down, but she says that the detective
You're
says,
suggesting that a detective would always write down something? Are you suggesting, because there was testimony from a detective that they don't write things down from civilians, 1 second, that they would always write down something that upended their entire investigation, that they would memorialize that always in a DD5? Is that what you're telling us?
well, they would bring her in for at least a formal statement. But more importantly,
You're just saying that, right? You don't know what they would do because counsel said that their method was not to take any notes if they didn't want to.
when there's somebody saying, I saw the shooter, that's not like somebody coming in and saying, I saw something, and so they just hang up. Somebody saying, I saw the shooter, it's not plausible that they would say, come in and make a statement. But more importantly, she says that when she was talking to the detective says, are you sure? Because they're saying that Anthony did it. Now, a detective, and this was testimony at the hearing.
Look at her face back here. She's just like, when are we gonna be done? When are we gonna stop this?
That a detective would not give a civilian information about an ongoing investigation. They would not say, are you sure? Because they're saying that it's Anthony who did it. That testimony about her phone call just doesn't add up. Rucker says that she asked Rachel to make a phone call and didn't ask her what she saw, that she called the police and the police didn't ask her to come in, that the police told her that they're saying it's Anthony who did it. It just doesn't add up. And Judge Chen had good reason to discount, especially since Rachel didn't come forward for 20 some odd years. And then he assessed her demeanor and said she was extremely evasive, and he didn't believe her. Now, I would also point out, Graves
You have
had...
one more minute.
Sorry?
1 more minute.
Okay, Graves was testifying at trial. He had already immunity. Sims was his best friend. They were good friends. There was good reason for him to take the gun and wipe it down. It was his best
Did the ADA
friend.
correct his false testimony that he had no probation violations? Because I think your adversary said something about 20 probation violations. He said everything was good with probation. Did the ADA have an obligation to correct that?
Well, what happened was this occurred on cross-examination. The defense counsel opened this cross-examination with, are you reporting regularly to probation? And
But
he
it was
said,
incorrect.
Yes. It was clear that the defense attorney knew that that was a lie because the next question was, is there a warrant for your arrest? And he says, yes. The defense attorney knew that he was not reporting regularly to probation because Graves didn't appear for trial, and the prosecutor asked for a delay of the trial to find Graves, And defense counsel opposed it, saying to the court, he has been gone for months. What makes you think he's going to find him right now? So defense counsel knew. He opens his cross-examination with, are you reporting regularly to probation? Knowing that he's setting him up either to say yes, and that's going to impeach him, or he's going to say no, and that's a lie. And then the very next question is there a warrant for your arrest? So counsel knew that Graves had disappeared for months, that he was not reporting for probation. He knew that.
I don't know, unless there was a follow-up question, like, isn't there a warrant for a probation violation? Like, if that question wasn't specifically relating to a warrant in relation to a probation violation, is that really telling the jury plainly that what he just answered in his previous question is untrue? Because it could still be taken as true that he's reporting and that there's a warrant, and maybe that warrant was for something else and that it was new and he hadn't had a duty to report yet. Like, there hasn't been a meeting. Like, I don't know.
There was a warrant for his arrest. It's improbable that when he was told that he was going to be that Graves was about to be arrested, he didn't ask for what. Of course, when he's told that Graves is about to be arrested, he asked for what? For probation violation. That's the opening of his cross-examination.
I think we have your point on that, and thank you both.
Thank you.
We'll take a very close look at this case. Number 6 on the calendar, matter of.
Oh. And then the opinion. The opinion. I should have started the stream without. I haven't read the opinion. I obviously know that it's overturning the conviction. So Ilan Mazel successfully argued his case. The state did not successfully, convince this panel that Judge Chen's decision should stand. Oh boy. But I should have started the stream like not saying what the outcome was and then just watch those oral arguments, because I didn't know how those were gonna go, and just tried to guess, like, what do we think? What do we think this panel's gonna do after we watch that? She said, okay, shut up now. Oh man. So we've gotten, again, Supreme Court of the State of New York. This is not what we would typically think of the state's Supreme Court. This is the Court of Appeals. It's their second division. On the panel, we had Betsy Barrows, we had Valerie Braithwaite Nelson, Barry Warrett, who was the guy on the right-hand side, and Elena Goldberg Velasquez. So we have, let's see. Wow, long list of names here. Lots of counsel. And then it was Solomon Newbort who did the arguments here. Let's see. Appeal by the defendant by permission from an order of the Supreme Court, Kings County, from Danny Chen. So again, that's the trial court. Dated March 10th, 2023. It's the court that heard the post-conviction relief. It wasn't the same trial judge. Which, after hearing, denied his motion pursuant to CPL 440, Section 10. To vacate a judgment of the same court, James Starkey rendered June 21st, 1991, the original trial judge, convicting him of murder in the 2nd degree and criminal possession of a weapon in the 4th degree, upon a jury verdict and imposing sentence. So ordered that the order is reversed on the law. The defendant's motion pursuant to CPL 440-10 to vacate the judgment is granted. The judgment is vacated, and the matter is remitted to the Supreme Court, Kings County, for a new trial. In 1991, after a jury trial, the defendant was convicted of murder in the 2nd degree and criminal possession of a weapon in the 4th degree in connection with the May 18, 1999 shooting death of an employee at a Brooklyn restaurant. At trial, the people's evidence with respect to the defendant's guilt included, among other things, the testimony of Julius Graves, the defendant's close friend and the sole eyewitness to the shooting, who identified the defendant as a shooter. The people also presented the testimony of Shalima R., who testified that on the day of the shooting, she was visiting her friend in a second-floor apartment across the street from the restaurant. From the window, she observed 2 men enter the restaurant. Moments later, she turned away. After she turned away, she heard loud gunshots. When Shalima R. looked back at the street, she saw the same 2 men running out of the restaurant. One appeared taller than the other, and the taller man was holding a big gun. She was unable to identify anyone in the courtroom as someone she'd observed on May 18, 1998. The people also introduced evidence that the defendant was taller than Graves. The defendant was sentenced on June 21st, 1999. This court affirmed the judgment of conviction. The defendant's application for leave to appeal to the Court of Appeals was denied on June 28th, 2002. The defendant moved pursuant to CPL 44010 to vacate the judgment. In support of his motion, the defendant argued inter alia that newly discovered evidence, which included a statement of Rachel L., that she had witnessed Graves leaving the restaurant holding a long gun on the day of the shooting, undermined the people's identification theory, and was therefore material to that issue. The defendant also relied on new statements by Shalima R. recanting her testimony and asserting, among other things, that she had initially told police that she could not describe the person she saw holding the gun. Shalima R. described tactics used by the police, who separated her from her children and questioned her for hours until she gave a description that matched the defendant. So, this detail, the panel thinks it's very important that this played a role. And I would agree, now that I'm thinking about it, because we didn't read about this in the articles. But one of the arguments and part of her recantation is that they separated me from my kid, and I had to sit there until I gave them what they wanted and they were satisfied. The defendant maintained that it was Graves who shot the victim. The Supreme Court, not the Supreme Court, conducted a hearing on the defendant's motion, at which it heard testimony from Rachel L. and Shalima R., among others. In an order dated March 10, 2023, the court denied the defendant's motion. The defendant appeals by permission. So this is the appeal of Judge Chun. CPL 440-10-1G provides that a court may vacate a defendant's judgment of conviction upon the ground that new evidence has been discovered since the entry of judgment based upon a verdict of guilty after trial, which could not have been produced by the defendant at the trial, even with due diligence on his or her part, and which is of such character as to create a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant, provided that a motion based upon such ground must be made with due diligence after the discovery of such alleged new evidence. And then more. So, to vacate a judgment of conviction based on newly discovered evidence, a defendant must demonstrate that the newly discovered evidence fulfills all of the following requirements. So 1, it must be such as will probably change the result if a new trial is granted. 2, it must have been discovered since the trial. 3, it must be such as could have not been discovered before the trial by the exercise of due diligence. 4, it must be material to the issue. 5, it must not be cumulative to the former issue. And 6, it must not be merely impeaching or contradicting former evidence. So, lots of criteria, lots of boxes that have to be checked here by the appellant seeking this vacation of the judgment. The court must make its final decision based on the likely cumulative effect of the new evidence had it been presented at trial. In order to fully appreciate the likely effect of the new evidence at the trial, it must be considered in the context of the relative strength of the people's evidence of guilt. So, I think that part right there is real important. Must be considered in the context of the relative strength of the people's evidence of guilt. So, we heard Elan argue that, I don't think a grand jury would indict this. I don't think a jury out there from Brooklyn would convict. Because they don't have, there's no strength left to their case. It's completely blown up. He used a lot of colorful language. It was he was interesting to listen to argue. Very articulate, but also had very succinct and creative ways of saying things. The resolution of the inquiry into whether the evidence adduced at the hearing is of such character as to create a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant. Is dispositive of a court's determination of a motion pursuant to CPL 440-10-1G. In carrying out this task, the hearing court is obligated to conduct a critical analysis of this evidence. It cannot merely engage in the mechanical exclusion of such evidence. This is their findings. The Supreme Court, so Judge Chun, erred in denying the defendant's motion to vacate the judgment based on newly discovered evidence. It should have been granted. At trial, Shalima R. testified that she saw 2 men fleeing the restaurant and that the taller man was holding a big gun. Her description of the taller man holding the shotgun corroborated Graves' testimony identifying the defendant as the shooter. At the CPL 440-10 hearing, however, Shalima R. recanted the critical aspects of her trial testimony. She testified that she could not make out any physical characteristics of the fleeing men, that that detectives separated her from her 4-year-old son during questioning, and that she felt pressured to fill in gaps with information that was told to her. Moreover, at the hearing, the defendant proffered testimony of Rachel L., who testified pursuant to a material witness order, that she was 17 years old at the time of the shooting, that she resided in the building adjacent to Graves' building, and that she knew both of the defendants and Graves. She testified that on the day of the shooting, she was standing across the street from the restaurant and heard a loud gunshot. Rachel L. testified that she saw Graves running out of the Chinese restaurant with a long gun, and that Graves had threatened to, quote, shut her up shortly after the defendant's arrest. Rachel L. acknowledged that she initially denied that she saw anything, and asserted that she was reluctant to testify at the hearing, explaining that she feared for her safety, which is reasonable. When Rachel L.'s testimony is considered in light of Graves' trial testimony and Shalima R.'s recantation, there is a reasonable probability that had such evidence been received at trial, the verdict would have been more favorable to the defendant. Therefore, the Supreme Court erred in denying the defendant's motion to vacate the judgment based on newly discovered evidence. The defendant's remaining contentions are without merit, so that's the only thing that they weighed. Accordingly, we reverse the order, grant the defendant's motion pursuant to CPL 44010 to vacate the judgment. They vacate the judgment and remit the matter back down to the Supreme Court, Kings County, for a new trial. And we'll see what the prosecution, do they want to do anything about that? We'll get some updates. Thank you for being a new member. Welcome aboard. Thanks for becoming Green. We got the J1Z experiment. And good to see you, Derek, as well. We've got, let's see, this was published yesterday about the conviction, but I wanted to take a look at it. We read the whole order, but there's some statements that Mercury News got from the parties. So, we have, today my 28-year-old nightmare is finally over. The court's decision to reverse my wrongful conviction is not just a victory for me, but also a testament to the power of unwavering support. I'm eternally grateful to my incredible family, the tireless legal team, and every supporter who stood by me and never lost faith. This is Anthony Sims in a statement to the Daily News. Let's see. While I'm overjoyed to finally walk free, my relief is tempered by the profound frustration I feel towards a judicial system that took over 2 decades of my life. The system needs a lot of work, and my hope is that my case will serve as a stark reminder of the urgent need for reform so that no other innocent person has to endure what I have. Then we have, let's see, this is Alan. So Alan Mazel says it's a great day for justice. Anthony is an innocent man. He's always been an innocent man. He never should have been arrested. He never should have been prosecuted. He never should have been convicted. This is vindication, said his lawyer, Alan Mazel of Emery, Shelley, Brinkerhoff, Abadi, Ward, and Mazel. All right, let's see. The police labeled Anthony as the perp the day after the murder based on a tip from one of Julius Graves' relatives, and then it was tunnel vision. So, and there were some more quotes. Let's see. This is quoting from the panel. All right, and then on Wednesday, Gonzalez spokesman for the Brooklyn DA Eric Gonzalez Orellanav, said that the appeals court decision, we are reviewing the decision. So it's yet to be, they haven't really said if they're going to try to retry or what. So, and thank you again for becoming a member. What are the prosecutor's options to decide if they're going to try to retry this case? I really think that one panel, the justice that was like sitting there leaning, waiting to talk, I feel like he might have been like imagining in his head having the ability to defend this case himself if it were taken a retrial. Like he was just seeing in his head what he would be arguing probably before it even got to the trial, right? Like motion to dismiss as soon as it was refiled. What he would argue. He was not with it. I don't think the whole panel was with it. So, let's see. Brooklyn says the headline's going to read, "Murder case roars back as court orders new trial." Well, it wouldn't be the court ordering it. It would be, refiling and then a decision on a possible pretrial motion to dismiss. We got tomatoes here from Aaron. Christy, earlier in the chat, I think you'd said you sent a case over on X with a tag. Let's see. I didn't get a mention over on X, but remember on X, it's Catnut Williams with a 0. So you might have tagged as like a profile that's not in use. That is just Catnut Williams, but it's not Catnut Williams, Catnut Williams. It's like Inception a little bit. So I'll drop my Twitter profile link in the chat there if you want to try to send it to me that way. You should be able to message me if we follow each other. I don't even know if I have my messages closed off to people I don't follow. Sometimes things get filtered. There's like a request box on... There's a request box on X that I swear filters people that I follow. So, oh man. But try that, and I'll see if I get a notification from you there. So, and then we've got some guy with cancer. Always good to see you. Says the police pressuring a witness? Never, never. Who would have thought? Who would have thought? Which case is this, Brooklyn? I don't see... If I type that, I don't see it. I do see like an old update that it roared back to... Let's see. I don't see anything with that headline. I see like an AI search result. That says it roars back to the forefront of the legal system. But if it is like in reference, this AI result looks like it's about this case, but it's about the opinion we just read, that the conviction's overturned. But that doesn't mean that the state's going to retry. They have to announce. All right, you put the link in Discord. Okay, so this one. Yeah, I think this is what they were referencing with the AI generated thing. So Brooklyn undercooked chicken murder case roars back as court orders new trial. Any statements? Yeah, so it still says here that the Brooklyn prosecutors are reviewing the ruling and will decide whether to retry Sims. So if they do, the case head backs to Brooklyn courtrooms for pretrial maneuvering and witness preparation. Graves remains uncharged, but could draw renewed attention if prosecutors pursue a different theory. Well, that would be fun. Or develop new evidence. Well, that would be fun. Sims' lawyers say the decision ends what they describe a 20-year nightmare for their client and puts the question of guilt back where they believe it belongs, in front of a jury, instead of resting on a trial record that is now more than 2 decades old. So, same thing. I know the headline says court orders a new trial. The state still needs to decide if they're going to refile the charges. So, but yeah, that's some additional interesting wording there. Are they gonna develop a new theory after all this time? So thank you, Brooklyn, for this Brooklyn update. And there we go. Yeah, Brooklyn prosecutors, not to be confused with Brooklyn 10952. And always good to see you, Brooklyn. Guys, that wraps it up for this deep dive. We went through another case. I got an ad popping up here. What else do we got? Oh, quick housekeeping. If you guys were... I'll just go to my own update quick because I have it handy here while I have X open. For the Alicia Andrews stuff, if you guys were following that, there was a status hearing on the 10th. And I just saw this was uploaded with updates. So right now we're waiting, with a new judge. Now that a judge has been tapped in, the defense has asked for reconsideration of their motion for judgment of acquittal notwithstanding the verdict, and they want to ask this judge to reconsider some of the rulings now that it's a different judge. They had filed one motion, and I'd shared a video of Lisa Figueroa over at the YouTube channel, The Florida Defense Team. She did a really good summary of that filing. The defense says they're going to file a supplement to that motion, and I believe that should be coming across the docket, because once they file that, the state has until April 3rd to respond to all of it all together. And then the defense will have until 7 days after the state's response to issue their reply to that. So a hearing has been set for May 11th when all of that stuff should be done and handled, and the judge would have time to review some of it. But when those supplemental filings and then the state's response and the defense's response to that, I'm going to read it all together. So once we get that supplement, we'll read all of it. That should be like an hour and a half stream. It's going to be a lot. And we'll read the state's response. But if you've been following the Alicia Andrews stuff, waiting for an update, it's on the way. It's on the way. Saw that posted today. So that's all I've got. I heard Corey Richens, like, state rest and then defense rested in Corey Richens. So the Corey Richens isn't putting on a case. Yeah, not a single witness. So there's that. I guess I'm not going to redirect you. I think this is set to redirect over to Defense Diaries for Corey Richens. But if that's not happening, I mean, who else do we got? Unless they're still live. Let's see. Yeah, actually, it looks like a lot of Corey. Let's see. Maybe I gotta refresh. Yeah, Defense Diaries is still live, so we can leave that. We can still go over there. Or we could go over body cam footage at Credence and Mikey. Because shout out to Defense Diaries. I don't mean to change away from them, but I'm assuming they're going to be wrapping up. So we could do Credence and Mikey. No Corey Richens. It's done for the day. He's just watching body cam footage and reacting, or maybe both of them are on today, so we'll see. Wait, we have an update. The judge is still making them try to come to a decision? Isn't this the third or fourth time they said that they're deadlocked? All right. Yes, I think that's the video, so I'm going to rely on Adventure Aaron's words there. And then real quick, Ben had said 3 hours ago, the jury in the Ed Holly case, that's that Orange County, New York trial where the jury keeps saying they're deadlocked. They've asked if they're allowed to Google DNA. It's been a time. They today also asked for a readback of testimony from a Wallkill resident who said she saw cars cruising through her apartment complex that prosecutors believe were connected to the victim, Megan McDonald, and the suspect, Holly. This is the same apartment complex where Megan's car was found abandoned with her cell phone and blood inside. This extra effort to reach a unanimous verdict comes a day after the jury foreman wrote to the judge saying they were deadlocked. The judge said to keep trying, and it appears they're doing that. And they were going to do that readback. So, still haven't come to a decision. So, we've got, the jurors are going to revolt there. Yep, I heard Kelsey Fitzsimmons had, like, more than one good ruling. Unfortunately, I don't know the specifics yet because I've been on stream since that was happening. We tried to jump over there right before they read the verdict in the Cole Goldberg trial. But I know, I think Brother Counsel's been doing updates on that. Nick Starr will probably do a video if he was busy doing Corey Richens this morning. Melanie Little was streaming it live. Broken Baker, I sent you guys over to, but couldn't hang out with you guys because I had a meeting. So I'm going to defer to the specifics. I heard it was good news, but that's as specific as I can get. So, let's see. We've got... Alright, so the redirect is set. It's just going to be casual body cam watching. Nothing intensive or that'll piss you off, hopefully. And then, Christy also said she had an interesting story. Oh, okay, this is a whole case. All right, so thank you, Christy. I got it over on Discord, but I opened it up. It looks like a decision overturned in relation to free speech, First Amendment. So that'll be interesting. It's 25 pages, so I got to look at that. But thank you, Christy, for sharing and also like going through the links to share it after it didn't work over on X. Other than that, you guys, Mel, hope you have a great rest of your birthday and good to see Raynette popping in here. Mel, have a good rest of your birthday. We saw in the chat you were going and getting your birthday gifts. Get all of them. Hope they are awesome. Hope you enjoy your day. Thanks for spending a little bit of your birthday over here with us. I'm honored. And